Hi there, it's Jess here from the Workplace Compass podcast series. Just a quick note before we get started on this episode. This episode, Sarah and I recorded before the government published the implementation roadmap for the bill and some new proposed amendments. And so therefore a few important things have moved on since Sarah and I had the conversation you're about to listen to. We now know, in respect of day one unfair dismissal, that's expected to come in some point in 2027 and not autumn 2026. The fire and rehire provisions have been narrowed, so changes to duties or location are now going to be excluded, and therefore it will be easier to make those changes under the new law. Variations clauses, there's been a slight crackdown on those. So a clause that lets employers make unilateral changes to restricted terms like pay or hours, they are going to specifically be treated as restricted variations themselves. So it'll be much harder to use variation clauses potentially. And then finally, the 0 hours framework has been updated to include some extra protection for agency workers. So with all that said, everything that we do talk about in this episode is still highly relevant, and we think it gives some useful insight into where things are heading and what this all means for workforce planning. So we'd invite you still to listen and enjoy the episode and let us know what you think. Many thanks. Hello everyone, and welcome back to this podcast series where we are exploring some key issues shaping the world of employment law and HR best practice. My name's Jess. I'm an employment lawyer and professional support lawyer at VWV.
And I'm Sarah, a senior HR consultant at Narrowkey HR. Today we're focusing on something that will be front of mind for many employers in 2025, how to prepare for the Employment Rights Bill.
Yeah, so the bill is expected to make some of the most far-reaching changes to employment law that we have seen in years, and they include introduction of day one unfair dismissal rights, protection for 0 hours workers, and an effective ban on the practice that we know as fire and rehire.
We'll unpack what those changes mean in practice and look at how employers can respond in a way that supports business continuity, legal compliance, and employee confidence.
So let's start then with the proposed move to day one unfair dismissal rights. So at the moment, as our listeners will know, employees usually need 2 years service before they can bring an unfair dismissal claim. But under the bill, the statutory provision that requires that 2 years service is going to be repealed. So in theory, that protection is going to start from the moment that employment starts.
That's a significant change, and it means the bar for justifying dismissals will be higher, even for very new employees. Employers are going to need to take much more care around probation management of early stage concerns, and documenting decisions properly.
Yeah, that's right, because although this requirement for 2 years service is going to be repealed, that's not all the bill does. And alongside that, it's introducing something that is called the initial period of employment, or the IPE. And that's going to be a new statutory concept, which is intended to provide some flexibility for early dismissals. So in practice, as long as an employer manages an early stage dismissal in the right way during that IPE, it is going to be possible to fairly dismiss. So the IPE, it's not the same as a probation period in the contractual sense. This is going to be something that is set out in statute. It's expected to be a 9-month period. And during that time, there will be a lighter touch test that's going to apply for employers who are seeking to dismiss staff in limited circumstances. And that will apply for any dismissals that take effect during the 9-month IPE, or for up to 3 months after the IPE finishes, as long as notice is given whilst the IPE is ongoing.
So Jess, do we know how that's actually going to work in practice?
Well, we know bits and pieces. So the government has said that during the IPE, there will be a lighter touch test to achieve a fair dismissal. Um, it's important to know that you will only be able to apply that light touch test where the reason for dismissal relates to the individual themselves rather than to the business. So if you've got a conduct issue, a capability issue, or potentially some form of some other substantial reason dismissal that relates to the person themselves, so say a personality clash, then you'll be able to use that lighter touch process during the IPE. But if you're looking to dismiss somebody for a business related reason, so redundancy or organisational restructure, then that light touch process won't be available to you, and the employer will need to carry out a full process even from day one. And the other thing is that although this process that will need to be followed during the IPE has been described as being light touch, we're not actually sure in practice what it's going to look like. So the government has suggested that it will, as a minimum, require a meeting, and that the right to be accompanied to the meeting will apply. But some commentators are sort of unsure about what it's going to look like in practice, really, because fairness is a very well-established legal standard. So if you're looking at introducing a lighter touch process, or effectively different levels of fairness depending on length of service, or that might be quite hard to achieve in real practical terms.
Okay, so while this IPE might offer some reassurance for things like poor performance or early conduct issues, it's not going to help in situations where there's a restructure on the cards.
Yeah, exactly. So employers in those circumstances are still going to need to explain the reason for dismissal and follow that full correct procedure. But as I say, if you're dismissing for a reason personal to the employee, then that lighter touch process will be required. So in either case, really, as an employer, you're going to have to be clear on the process that you're following. You're going to have to be really good at keeping strong contemporaneous evidence to back up any decisions that you're making. And you're going to need to be able to provide really strong support for line managers who are handling any concerns that might crop up during probationary periods.
So there are two things that, from an HR perspective, jump out at me there. Early planning is going to be really important to make sure that everybody understands this new landscape, and making sure line managers understand and are trained will really pay off, especially if you to minimise any legal risks around dismissal.
Yeah, definitely. And I think alongside that, there's an opportunity now, before the law actually changes, for employers to review probationary procedures now. So things like what templates you've got, how that probationary period is managed, how check-ins are run, what guidance you've got in place for escalating concerns, and like you say, Sarah, what management training you have available. So making those structures more robust will help de-risk these early dismissals under the new framework. It's probably also worth saying, in terms of the timescales for the implementation of these changes, that the government has said that these provisions are not going to take effect before autumn of 2026. So they're a little way off, but important to prepare now.
Okay, so what else is happening, Jess?
Well, another really key area of the bill is around this new protections for 0 hours and casual workers. And this is part of a much wider push to ensure that flexibility in terms of working patterns and the gig economy isn't coming at the expense of fairness.
Yes, and we've certainly seen quite a few high-profile cases in the media over recent years. My understanding is that one of the proposed changes is going to be the introduction of an obligation on employers to make what will be known as a guaranteed hours offer to 0 hour and low hours workers, when their working hours reach a threshold over a defined period of time. So I think a lot of the detail is still to be fleshed out in the regulations, but that seems to me to represent a really significant change in the landscape around how we engage with 0 hours workers.
Yeah, it's really going to be massive. And like you say, there is lots of detail to be fleshed out. So we don't know what that hours threshold is going to be yet. And we don't know the reference period that you're going to have to look across in order to work out whether the obligation to make a guaranteed hours offer has been triggered, although I believe that the government has said that it favours a 12-week period, at least for the initial reference period. And as well as the guaranteed hours offer framework, there's also the proposal under the bill to require employers to pay compensation to 0 hours and low hours workers for short notice shift cancellations and late changes. So if a worker is asked to cancel or change a shift at the last minute, then they may be entitled to pay even if they don't end up working.
So again, that's going to represent quite a significant change, and it's going to mean that employers are going to have a much greater focus on how they're handling scheduling. So I guess relying on things like informal messaging or late changes more generally might carry a much greater financial risk once the bill's in force.
Yeah, absolutely. And something that we do know about the bill is that it includes what is known as multi-worker offers. So this is a really interesting and quite a worrying part of the bill in terms of how employers manage the allocation of work to 0 hours workers currently. But for example, if you've got, say, a group WhatsApp with lots of your casual staff on it and you're using that to, put up shifts up for grabs for the first person to reply, can take the shift on. Technically, that could be a multi-worker offer. And, if you're not managing it very carefully, you might end up falling foul of this requirement to pay compensation to everybody else who doesn't end up working the shift. I think, a lot of this is going to be thrashed out in the detail of regulations and consultations coming. So hopefully those kind of practical issues will be resolved at that stage. But yeah, it's definitely a big one for employers to watch. And, in terms of what employers can be doing now, it's really sensible, I think, to review contracts and scheduling systems even before the law changes and just have an eye to where the challenges might be. Make sure that there's some really clear processes in place to reduce the need for last minute adjustments later.
Yeah, that sounds like really sound advice. Lots to think about and plan for in respect of those 0 hours workers. Join us next week when we're going to be talking about the end of fire and rehire as we know it. Many thanks.